What's up, everybody? It's Bring Decisions here, and today I want to come to you with another aspect of going into trial or even executing in court. Now, I labeled this the art of listening. Now, this is going to be more of a conversational piece, but I want you to listen to the actual story. Now, I had an issue with Bank of America. So I was being charged at the time because I had a construction company. I was being charged with a check that was written from a client for my company from Bank of America. So the client wrote the check. They had an account at Bank of America. They wrote it to my company, which also had an account at Bank of America. So before I deposited the check, I went and had them verify it. So again, Bank of America check to my company, verified with Bank of America prior to the deposit. Now, in the aspects of this deposit, come to find out that after the verification from Bank of America, that the check itself was fraudulent. So they went to charge me civilly for the fraudulent check, even though they had already established that the check came from somewhere else. So I go into court, and one of the things that was amazing was I wrote up a dismissal because they lacked a foundation in which to actually charge me with the check. So on this dismissal, it was dismissed res judicata, right? Which means the final order, whatever, already been determined. Well, while I'm handing these out, because I had a copy for myself, the prosecutor, as well as the judge, the prosecution, or excuse me, I shouldn't even call them, the counsel for Bank of America, because it wasn't a prosecution, the complainant, which was the Bank of America, their representation yells out, one of the guys yells out, res judicata, motion to strike for language unknown. Now, most people, a natural reaction is to immediately go after the strike because that's the opposition. Well, I heard something. So I used it to not only place myself into a better position, but to show that I had the ability to pay attention and act on opportunities given. I yell out, I apologize, my honor. I agree to a continuance so the complainant can find competent counsel. Why did I use that? Because remember, it's verbiage. So plaintiff can find competent counsel. Because one of the reasons to fire an attorney is lack of competence. They are incompetent. They don't know the language. And he goes, what do you mean? The dude that yelled it out. The judge goes, well, you just yelled out in court that you didn't know what res judicata means. And I turn around and I say to him, it's on the first page of definitions. So what happens is, now it's on the record that this guy is incompetent. So therefore, I've limited his ability to actually work. I've also given everyone that he goes up against a bullet in the chamber for going against him because he lacks competence. That is now on the record, and it will be on the record until he passes. But I never had to address the strike. The dismissal stood because of his incompetence. Now, could I have won the motion against the strike? Absolutely. However, just like in chess, you take advantage where you get the greatest advantage from. Fighting the strike would have allowed him to stay on the case and would not have affected him later. It also would have allowed them to stay on balance. I took them off balance by making them hire someone else. And then that new person was like, you know what, it's not even worth the fight to go against it because it's costing you more money to fight him than to actually leave it alone. And this is one of the things that I tell you, stay focused because every opportunity doesn't look just like paperwork because 99% of these litigators have no idea how to tell a story and 99.9% of them have no idea what you are saying to them because most of them do not speak the language of even the court. So listen to what's being said, then pay attention because a lot of times the show is not for you.